For legal egals, exclusively. Polish Simplified Restructuring Proceedings. The Act of the 19th of June 2020 on interest subsidies for bank loans granted to entrepreneurs affected by the effects of COVID-19 and on simplified proceedings for approval of an arrangement in connection with the occurrence of COVID-19. Chapter 6. Simplified Restructuring Proceedings. Article 15. Section 1. By the 30th of June 2021, an entity to which the provisions of the Act of the 15th of May 2015 Restructuring Law apply and which has concluded an agreement referred to in Article 210 of said Act with a restructuring advisor, may announce in the Court and Commercial Gazette the opening of the proceedings to approve an arrangement conducted pursuant to restructuring law, which are applicable to the proceedings to approve an arrangement as amended by the regulations below. 2. The announcements, which are referred to in Section 1, may be made by each of the entitled entities only once. 3. The announcement referred to in Section 1 must contain as follows: the first name and the last name of a debtor or its business name, its place of residence or registered office, its address and parcel number or the National Court Registry number, and if such data are lacking, other data enabling its unambiguous identification, a statement on the opening of the proceedings to approve an arrangement, the first name and the last name of the arrangement supervisor or the name of a commercial company which is the arrangement supervisor, and respectively the number of the arrangement supervisor's license or the company's National Court Registry number, together with an indication of the arrangement day. 4. The court competent for processing an application to approve an arrangement, as referred to in restructuring law, must be notified of the announcement referred to in Section 1 by the arrangement supervisor within 3 days of making the announcement. 5. The announcement which is indicated in Section 1 may be made once the debtor has prepared arrangement proposals and the list of receivables and the list of disputed receivables and has handed them over to the arrangement supervisor. Article 16. 1. The day of making the announcement, which is set out in Article 15, Section 1, is the day of opening the proceedings to approve an arrangement. 2. The arrangement day may not fall earlier than on the day at least 7 days before filing the application to make the announcement, and not later than 7 days after it has been filed. 3. As of the day of making the announcement, which is referred to in Article 15, Section 1, and until the day on which the proceedings to approve an arrangement are discontinued or closed. Subsection 1. The enforcement proceedings concerning the receivable, which is subject to the arrangement by operation of law, as well as concerning the receivable referred to in Article 17, initiated before the day of opening the proceedings referred to in Section 1, are suspended by operation of law. Subsection 2. Initiation of enforcement proceedings and performance of a decision on granting security for a claim or performance of an order to grant security for a claim arising from the receivable, which is by operation of law subject to the arrangement, as well as the receivable which is referred to in Article 17, is not allowed. Subsection 3. The provisions of the following articles: Article 252, Article 253, and Article 256 of Restructuring Law apply accordingly. The consents referred to in Article 256, Section 1 of the Act of Restructuring Law are issued by the arrangement supervisor. Article 17. 1. If arrangement proposals provide for full satisfaction of the receivable, which is referred to in Article 260, Section 1 of Restructuring Law, within the time limit specified in the arrangement, together with incidental amounts due, which were stipulated in the agreement, which was the basis for granting security, even if such an agreement has been effectively terminated or has expired, or its satisfaction to a degree not less than what may be reasonably expected in case of collection of such a receivable together with incidental amounts due from the objects of security, the creditor's consent is not required to subject this receivable to the arrangement. 2. The provision of Section 1 applies accordingly to receivables secured in the manner set out in Article 249 of Restructuring Law. Article 18. 1. At the request of a creditor, the debtor or the arrangement supervisor, the court may cancel the effects of making the announcement, which are referred to in Article 16, Section 3, if they are detrimental to the creditors. Before issuing the decision, the court may examine the debtor, the creditor, or the arrangement supervisor. The cancellation of the effects of making the announcement also lifts the restrictions imposed on the debtor in its administration powers, which is referred to in Article 22, Section 1. 2. The arrangement supervisor announces the cancellation of the effects of making the announcement, which is referred to in Article 16, Section 3, in the Court and Commercial Gazette. Article 19. 1. Irrespective of collecting votes referred to in Article 212 of Restructuring Law, the arrangement supervisor may set a day for the creditors' meeting for the purpose of voting on the arrangement. The arrangement supervisor presides at the creditors' meeting. 2. If the receivables referred to in Article 17 are subject to the arrangement, the creditors referred to in Article 17 must be deemed as a separate category of interests. 3. If it is technically possible, the voting during the creditors' meeting may be held with the use of electronic means of communication. The voting held with the use of electronic means of communication includes, in particular, transmission of the creditors' meeting in real time, when the creditors may speak during the meeting while present at a location different than the location where the creditors' meeting is held. The creditors' participation in the meeting may only be subject to such requirements and restrictions which are necessary to identify the creditors and to ensure the safety of electronic communication. The minutes of the creditors' meeting held with the use of electronic means of communication must include a recording of the session on an electronic data carrier. 5. The provisions of the Act of Restructuring Law and Article 264 of this Act apply accordingly to the creditors' meeting scheduled by the arrangement supervisor. 6. Acceptance of an arrangement governed by these provisions is determined pursuant to Article 119 of Restructuring Law. The arrangement supervisor acknowledges the acceptance of the arrangement. End of Part 1.